Hi, everybody. My name is Paula Price, and I'm with the People's Law School. You are here for Settling in a State in British Columbia Town Hall Edition. And this is our webinar where we will have our guests, Nicole Garton and Stacey Ayukawa of Heritage Law, answer questions that you have submitted to us live. And not sure if you were able to tune in for a previous webinar, but if you want to learn more about settling an estate in BC, I encourage you to check out the initial webinar from June of this year, Settling an Estate in British Columbia. It's available on our website. Now, this webinar in structure is focused on your questions. These are questions that you submitted to us in advance of this webinar. We received over 50 questions. And so what we have done is we have organized those questions into 4 themes, and a big shout out to Drew Jackson for all his hard work behind the scenes getting that ready. We've got 4 topics: the executor's role, we have dealing with the property and debts, we have paperwork, and then we have a section on the rights of others, including those left out of the will. We're about to introduce our speakers, and before we get there, we just like to acknowledge a few, make some acknowledgements. First of all, we would like to begin by acknowledging that the land on which our team is gathered is the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We would also like to acknowledge you. We had about 340 registrants sign up for today's webinar, which is incredible. We are so excited. Our mission is to provide legal information to the public. And so when you sign up for our webinars, it allows us to do that. And we are thrilled to have you here. We'd also like to thank the Law Foundation of British Columbia. They are our primary funders and they make this type of programming possible. And finally, we'd also like to thank our speakers. So with that, I would like to introduce Nicole. Nicole is the founder of Heritage Law, and she's a lawyer and mediator whose practice is focused on estate planning, administration, and disputes. So welcome, Nicole.
Thank you.
We also have Stacey Ayukawa. Stacey is a paralegal with Heritage Law, and she is an instructor at Capilano University, where she teaches wills and estates. So welcome, Stacey.
Thank you.
And with that, we are going to get started with our questions. And the first topic is in regards to the executor's role. So the first question is for you, Stacey. And the question is this: if an executor is named in a will, can they transfer their role if they are too busy to take it on?
So yes, is the short answer. But it happens, a lot of people find that they may think that they are obligated to act as the executor if they're named in the will. And maybe at the time that the will was prepared, they agree to act as executor. But then later on, when the time comes and the will maker has died, the executor is not able or is unwilling to assume that role. It doesn't have to be because they're too busy. There could be other reasons. They could be ill, or they could just be overwhelmed with the amount of work. Maybe they didn't understand how daunting the task can be. And in that case, they can renounce their rights to be the executor of the estate. If there's an alternate executor appointed in the will, then it would fall to the alternate executor. And if there is no other person to be the executor, then someone can, sorry. Then someone can then, sorry, I'm lost now. Okay, so however, if if someone has been appointed as an executor and they have intermeddled in the estate, which is something like holding themselves out as the executor, then they may be compelled to continue to act in that role as the executor. So it's very important to make sure that you're not holding yourself out as the executor, because, and like dealing with banks and things like that, because if you do, then you may be compelled to continue to act.
Super. So Stacey, if I'm understanding correctly, then you can transfer your role, but you don't want to take any steps, as it has to be before you start taking steps in your role as executor.
Yes.
Super. Thank you so much. Nicole, this next question is for you. In the event that the estate was very small, or the estate was too small and probate was not required, can the executor still receive a fee? And if so, when?
So the answer to that is yes. So probate, if somebody passes away with the will, which appoints an executor, the executor has authority the moment that that person passes away. Probate doesn't increase or decrease that authority. All probate is basically a piece of paper from the court affirming the validity of the will and the power of the executor. And you only need that basically piece of paper is if the deceased own real estate in their own name, or if there's about $30,000 or more in assets in the deceased name. So probate itself is not related to the executor's power, nor is it related to a fee. So for an executor to claim a fee, it can be set out in the terms of the will itself, or if it's not specified in the will itself, then you go to Section 88 of the Trustee Act, and somebody can charge a capital fee of between 0 and 5%. And then if there's ongoing trust, they can charge a care and management fee of up to 0.5%. So if you want to charge a fee and you've got beneficiaries who are all adults and capable, then if they consent to your fee, then you can charge it. If they don't consent to your fee, you can go in front of a special judge called a registrar, and they can make a decision about what an appropriate fee would be in that instance.
Excellent. And at what stage would you do that, Nicole? At what stage would the payment be made? Would it be under the terms of the will, or is it something, is there practice?
So in the normal course of events, you can, if a fee is prescribed in a will, you can actually take it at any time. Although it would be prudent to advise the beneficiaries in advance and have them sign a release to ensure that they're not going to contest that fee. If you're claiming pursuant to Section 88 of the Trustee Act, then you must provide the beneficiaries with what we call a statement of accounts. There's actually a prescribed form in the regulations of the Wills, Estates and Succession Act. And that's basically financial statements for the estate. So it's got all the assets and liabilities as of the date of death, all the subsequent debits and credits. And then there's often a holdback for any final taxes. And then in that document, you can claim your fee, if it's 0 to 5%. Usually provide that statement of accounts to the beneficiaries with the recommendation that they obtain independent legal advice, and then they either consent or they don't. But if you are claiming under Section 88 of the Trustee Act, you cannot take a fee until such time as you have express consent from the beneficiaries and or a registrar Supreme Court order. Also, if one of your beneficiaries is not capable and or below the age of majority, you're going to have to serve the public guardian and trustee and get the public guardian and trustee consent as well.
Okay. Thank you very much, Nicole. And this next question is for you, Stacey. And a question I imagine you hear quite often is, how long does probate usually take? And in this case, it sounds like somebody has been going through this process for a year already.
Okay. So there's a lot of things going on all at the same time when you're dealing with probate. And so what we usually tell people is that at the present time, it could take approximately between 4 to 6 months total to get the probate document. Now, that's not to complete the estate administration, because afterwards there could be, you will need to liquidate assets and things like that. But to get probate, there's a number of factors that you need to consider. The first thing that you do is you need to order a search of the wills notice registry in the Vital Statistics Agency. And that by itself will usually take between 1.5 to 3 weeks to obtain that document. You also need to serve or deliver a notice in Form P1 to all of the beneficiaries and intestate successors of the estate. You cannot file your probate application until 21 days after you have delivered that notice. So you have to wait at least that long before you can submit your application. The other thing that you need to consider is, and all of these things are happening at the same time. So you filed to get your wills notice search, you deliver your P1 notice, usually at around the same time. And then the other thing that you have to consider is the waiting on banks and financial institutions to provide you with the date of death information that you will require you will be required to fill out in the P10 affidavit of assets and liabilities before you can submit your application for the grant of administration. So banks are sometimes reluctant to give out information, and it depends on the circumstances, and it depends on the bank and sometimes even the branch as to how long you might be waiting to get information regarding the deceased's accounts held at that institution. So it could take a month to get information from them, or it could take longer. And if you are having trouble with dealing with the banks to get that information, there's a separate procedure that you can follow to receive from the court registry what's called an authorization to obtain estate information. And it's basically a piece of paper that you will then serve onto the bank or financial institution that you're looking to receive information from. And they need to then provide you with that information within 30 days of that notice being delivered. So there's that. And then the other thing is that once you have everything, you've got your wills notice search, you've waited the 21 days for the notice, the P1 notice delivery, and you've got all of the information from the banks, then you have to submit your entire application to the probate registry. At present, the probate registry is taking around 6 weeks to 2 months to process applications. And it really depends on when you submit your application. So if the registry is really busy at that time, then it may take longer. Or if they're not very busy, it could take less time. The thing is that with COVID right now, I think they are short-staffed because not as many people are working in the office, from what I understand. And then the other thing that I should mention is that there is sometimes the ability for someone to ask for an expedited grant to be issued if there are extenuating circumstances. Now, it really depends on what the circumstances are, because the court is being much pickier on issuing those expedited grants at present. So it has to be something, you have to have a reason that is really compelling to the court in order for them to consider an expedited grant. Something like having a pending real estate sale on the deceased's property has sometimes worked and sometimes not. So it really depends on the circumstances.
Super. Excellent. Thank you so much, Stacey.
I just want to jump in. Under a lot of people die intestate, which means without a will, and sometimes they pass away with like running businesses and things like that. Under Section 132 of WISA, you can actually get an emergency letters of administration if there's special circumstances. So that allows somebody to step in and secure the business and or protect assets on an urgent basis.
Thank you, Nicole. We're going to take one live question in relation to this topic, and then we need to move forward just so that we can have time for the other topics. Here's the question: if the alternate executor refuses to act as an executor and there is no one else, what happens to the estate? Who will take care of it?
So I can answer that. So that's called letters of administration with will annexed. So what that means is it's a court-appointed executor with the existing will. And so if somebody renounces because they're unable to do it or they're choosing not to do it, there's a lot of estates where there can be significant liabilities. And, being a fiduciary, which is what an executor is a very thankless task. It's full of risk and liability, and it's very thankless in many ways. So you can get maybe a professional executor to step in, or sometimes the public guardian and trustee will step in.
Super. Thank you so much, Nicole. So we're moving into our next section, which is dealing with the property and debts. And our first question here is for you, Nicole. Why won't the bank give me access to my mom's old account?
Well, if she's passed away, then the banks generally freeze accounts until such time as they can evidence authority to deal with the account. So as I referenced before, if it's 30,000 or less, quite often the bank will work with a will and a death certificate, although not always. If it's more than that, then you're going to need that court sort of certification, which we call probate, to permit the bank for the bank to permit you to deal with the account.
Thank you. And there's a follow-up question that we had that's somewhat related, where we had a situation where somebody's brother's wife passed away without a will. He's the administrator. There was less than 15,000 in her estate, and he believed that made probate unnecessary. And when he was dealing with the bank would not release the funds and told him that they've closed the account and he should have had the estate probated. Do you have any comments on that situation? It sounds like what you would have said is that the death certificate would have been sufficient, but any thoughts?
Well, the banks are not the most reasonable or business focused people always. So I think, they want to mitigate risk. And so it's not unusual that it takes a bit of negotiation and unfortunately sometimes hiring a lawyer to deal with the bank.
Okay, super. Thank you so much, Nicole. So our next question is for you, Stacey. In this case, the deceased owed more money to credit cards and a line of credit than he had in the bank. He had no other assets except a few small things in the apartment. And the question is, what steps do I take to settle up with the banks?
So this is actually very similar to what Nicole just answered in terms of settling up with the banks. This, if the deceased owed more than he owned, then it's called an insolvent estate. And the banks are again, very different with their procedures. It can vary from bank to bank on what they will require. Now, if in this question, I don't know if there is a will or if there is not, but Nicole sort of answered the question already if there is a will. But if there is not a will, then it's much more difficult to deal with the banks. You can give them the death certificate and show them your ID to try to confirm with them that you are the person that is able to deal with the estate. You know, if it was a married spouse and you had your marriage certificate, that would be, I think, compelling to the banks to have you deal with their account. But what's important to note is that the banks are a little bit reluctant to transfer the money just unless it's a joint account. If it's a joint account, then it can go directly to the surviving joint holder of the account. But if it's a sole account, then the banks are reluctant to just distribute that money to anyone. And they would prefer to put it into an estate account in the name of the deceased. We have done this, and when there is no will, where we showed them the original death certificate, as well as we prepared a statutory declaration of the person that they wanted to deal with the accounts, to confirm that they were the relative of the deceased, their next of kin, and that all of the other interested parties consented to that person to deal with the property.
Super. Thanks so much, Stacey. And quick follow-up, any insight on whether the costs associated with cleaning the apartment would have priority over the bank loans?
Yeah.
Yeah.
Oh, sorry. Go ahead.
I think somebody needs to think about whether they want to act in the role of the executor at all. So one of the things that we see, unfortunately, like we hear so much in the news about COVID and what a tragedy it is, and it really is. But one of the things is it's obscuring the news about the overdose deaths and the tragedy that is happening with that. So there are a lot of people passing away from overdose deaths, and not just British Columbia, but lots of places. And these are people that are not indigent people. Like a lot of them have jobs and, you know, lives and families and friends. And a lot of these people pass away intestate without a will. And it's not uncommon that their liabilities exceed their assets. If you're a family member or a friend, you have to think very carefully about whether, in this instance, for example, you want to step in at all, because really you're putting yourself at quite potential serious liability. Because if there's CR liability, if there's credit card liability, and you don't follow the distribution steps as these, you know, financial institutions and CRA feel is appropriate, they very much could come after you for potentially damages and loss. And so I think if there's any instance where someone has died and it's an insolvent estate, I think it would be prudent immediately to get advice, and whether it would even make sense from a business perspective to even step in that role at all.
Thank you so much, Nicole. It's such a sobering view on it, and something that unfortunately is a circumstance that we're dealing with in our current times. So thank you for that. This question, Nicole, is for you, Nicole. What happens when you have settled an estate and an unexpected debt comes up?
Okay, well, that's one of the sort of big risks out there. So,
Right.
okay, so when people consult lawyers, sometimes it seems a bit depressing because our job is to manage risk, right? So we have to think about what are all the risks out there? What are all the bad things that can happen? And then we help clients mitigate those risks to the extent possible. So if you are acting as executor of an estate or administrator, so court-appointed executor, there are sort of three categories of risk. So the beneficiaries aren't happy, the creditors aren't happy, and the CRA, which is, I guess, the most serious creditor, isn't happy. So, so the risk is, for example, you administer an estate in good faith, you ascertain the debts as far as you are knowledgeable of, and then, distribute the funds. And then 2 years later, someone says, Bob borrowed $10,000 from me and I expect it now. So, I mean, the very serious risk is that the executor could be potentially liable for that debt. How you mitigate that risk is you make full and diligent search of all debts. The other thing is you advertise for creditors. So there is a sort of a prescribed procedure in the BC Gazette where you sort of make a notice stating that this person's passed away. This is who the administrator is. And you say, please let us know of any and all debts. So if you make full and diligent search, you advertise in the Gazette for creditors, you get a clearance certificate from the Canada Revenue Agency, you get provide comprehensive and detailed accounts to beneficiaries and ask them to obtain independent legal advice. If somebody comes by 2 years later, you've met your duty. And so it would be difficult for them to successfully make a claim against you personally. But this is illustrative of why being an executor is very serious and something that you need to think about very carefully and understand that there is significant potential liability in that role.
Thank you so much, Nicole. Now we're going to turn to one live question on this topic, and it is this. What is defined as the estate's assets at the time of death? Are assets that are gathered post-death included, such as life insurance?
No, a life insurance policy, unless it is payable to the estate, it actually passes outside of the estate if it has a designated beneficiary. So life insurance proceeds would not be part of the estate assets as of the date of death. And all assets and liabilities, it's like are frozen in time as of the date of death. So if something came in later on, that would not be included in the assets and liabilities as of the date of death.
Okay, super. Thank you so much, Stacy. Now we're moving into the third topic, which is the paperwork. And in this regard, our first question is for Stacy. Is probate necessary where the deceased left no property and there's not enough money to pay the bank loans owed?
So again, this is something that we've talked about a little bit briefly previously today. If there is no property, if there's no like real property and there's less than around $30,000 in assets, then probate is probably not necessary. And if there's more debts than assets, then again, it could be an insolvent estate, and the debts would be payable in order of priority under WISA.
Excellent. Thank you, Stacy. Nicole, this question for you. I am the executor for an estate that doesn't require probate. In this case, the house was transferred before death. The accounts were switched to joint accounts. The income tax returns have been filed for 2019 and 2020. And the question is, what happens next?
Well, how have they filed income tax returns for 2020? That's actually impossible because those would be filed in 2021. But again, you want to think about the three categories of risk, right? Beneficiaries, creditors, CRA, and go through the checklist.
Super. Super. Thank you. And this next question is for you, Stacy. And the first part of the question is, does the executor need to share the inventory or a complete list of assets with all of the beneficiaries?
So the answer is yes. The executor is under a fiduciary duty to provide all of that disclosure to all of the beneficiaries. They have a duty to account, and that duty is satisfied when when they prepare their accounting to the beneficiaries, which will include all of the assets of the estate, all of the liabilities. It's usually put on a form, and then they need to get their accounts approved in order to receive remuneration for their for acting as the personal representative of the estate. So, and they need to detail every debit and credit that comes in and out of that estate account, so that they can prove to the beneficiaries where any money has gone and where any money has come in, so that at the end of the day, when the money is distributed and the residue is distributed, the beneficiaries can be certain that then properly accounted for.
Excellent. And I think you've answered that second part of the question. How detailed does a statement of account need to be? So that's basically keeping track of all of the expenses of the estate. Is that right?
Yes, correct.
Super. Thank you very much, Stacy.
And again, just a reminder, there's a prescribed form. If so, it's in the regulations of the Wills, Estates and Succession Act if people are looking for a precedent.
Excellent. Thank you. Nicole, we have our next question. Speaking of taxes, our next question is it's a three-part question. So I'll start with the first part. As an executor, what does one need to apply for a certificate of clearance from the Canada Revenue Agency?
So what you do is you file all the tax returns, and then there's actually two clearance certificates. So there's one effective as of the date of death, and then there's a second one which is for the estate. You know, there's a prescribed form that you fill out to request it, and I guess if you're doing the taxes yourself, you would do that, or the accountant could do it for you. What's the importance of a clearance? So the T1 filing is the regular tax return that you have to file for the deceased person in the year of death. But I mean, the importance of it is that the CRA can't come. So if you distribute the funds to the beneficiaries and then the CRA does a reassessment or something and decides that it wants another $10,000, the clearance certificate is a piece of paper that acts as a bar to them asking you for more money, right? So that's the importance of it. It means that the CRA is off your back, so you really do want it. What do I do with the clearance certificate after I receive it? You keep it in a safe place. Because,
Absolutely.
yeah, because you want that piece of paper in the event that CRA comes back and wants more money. So.
Super. Thank you so much, Nicole. Yes, it sounds like it really is something that you would like to have settled. Stacey, this next question is for you. When the estate is ready for distribution, after probate and receiving the CRA clearance certificate, are you required to engage a lawyer, or can the executor prepare the appropriate forms for the beneficiaries to sign off?
Yeah, so yes, no, they don't have to engage a lawyer if they want to continue to administer the estate themselves. Sometimes it's handy to have a lawyer to help, depending on the complexity of the estate, but it's absolutely not mandatory. And again, Nicole mentioned that there is a precedent form of the accounting or the statement of accounts that you need to prepare to account to the beneficiaries to fulfill your fiduciary obligation to them. With that precedent, you're able to account to them, and then you can transfer the property into your name as the executor of the estate, and liquidate assets and proceed with transmission of all of the property. If it's for real property, you might need to engage the services of a notary to help convey the title for the real property from the deceased into the name of the executor, and then again from the executor into the beneficiaries if that's what's going to happen, or if it's going to be sold, then that wouldn't be required.
Super. Thank you so much, Stacey. One last question in this section before we turn to the live question, which is for you, Nicole. What happens if an estate beneficiary will not sign off on the final release? And in this case, we have, all other beneficiaries, 10 in total, have signed off.
So that's not that unusual, actually. So you proceed in front of the registrar, which is that specialized judge. Okay, so you basically just present the accounts, explain that one of the beneficiaries is not responding or not agreeing, and then the registrar basically makes a determination as to the appropriateness of the accounts, and then it's settled.
Excellent. So you do have recourse.
Yeah. I just want to also just follow up on what Stacey said, is if you need a lawyer, you actually don't need a lawyer for any part of it. Like if it depends on the complexity. So if you're an organized person, there's a lot of forms and information available online, and a lot of it, if you're good at filling out forms and following checklists and things like that, you could do the whole thing from start to finish. By retaining a lawyer, you get two things. One thing is, because we do high volume, and so we can often do it faster just because we know the ins and outs of the procedures. And the second thing is that if an executor hires professionals to give them advice, so a lawyer in respective legal decisions and an accountant in respective tax decisions, that is a effective risk management strategy because they have followed the professional advice of experts. So, if there's issues later, it can be very helpful in terms of reducing the liability. But of course, you pay a fee for it. So, I think you have to make a business decision as an executor. Do you want the assistance and the reduction of potential liability, or is the estate straightforward enough that you can save the expense? And so you can make that decision at the outset.
Thank you so much for adding that, Nicole. And I'll just make a quick reference back to the original webinar that we did together, where we did talk about this question as well. And you'd said a similar, very much aligned comments about that. So thank you for adding that. This is our now we have one question on this topic, then we'll turn to the last topic. And so the question here is, my deceased mother appointed all three of us adult children as executors. She owned a house assessed at 1.4 million with no significant savings. I will have to cover the cost of the probate and taxes as my siblings are not able to contribute. What type of legal document can I have drawn up so that when the house is sold or rented, I can be assured of receiving the repayment of the fees from my siblings?
What I might do in that instance is that if you're going to be funding it, I might negotiate with the siblings that you are the only executor, because the last thing you want is to be fronting the expense, and then if there's pushback with them, then having to argue with them getting paid back. So I mean, my first thing would be to negotiate with them and say, okay, if I'm going to be the banker and front these funds, I think I want to have the sole authority to run this thing. But I mean, that would be certainly an appropriate expense of the estate. It would come out of the net sale proceeds of the house. And the reality is that these accounts can't be finalized until such time as all the debts are paid, and that would be a proper debt. And so basically the siblings would either agree, or again, you could have to go back to the registrar and get a court order. But so you would get your money. It just would depend on how cooperative or not your siblings are in terms of how long and how painful it will be to get it back.
Super. Thank you so much, Nicole. Yeah, so much of it depends, I guess, on the dynamic of what is going on. Speaking of siblings, we're in our last section, which is the rights of others, including those left out of the will. And our first question here is for you, Stacey, and it's in two parts. Where and when can one obtain a copy of a will to ensure the directives have been followed? And if the will is probated by the executor's spouse, who ensures that items were gifted as the deceased had wished?
So when the P1 notice is sent to all of the beneficiaries and intestate successors at the beginning of the probate process, or the estate administration process, I should say, the P1 notice, if there is a will, gets sent with a copy of the will. Okay, so all of the beneficiaries and intestate successors should already have a copy of the will. But if probate has been applied for and granted, the will actually becomes a public document, and it's searchable in the court registry. So if you wanted to search the court registry, you could contact the court registry and ask them for a copy of it, because the will does become a public document, and you'd be able to retrieve it. And then who ensures that items were gifted as the deceased wished? I mean, the executor, again, has that fiduciary duty to do everything as the will stipulates. So it's the right of the beneficiaries to question the executor if they believe that anything has been mishandled, and if it has, then they can bring up to the court an application to either remove the executor or force the executor to strictly adhere to the terms of the will.
Super. Thank you very much, Stacey. That's so interesting about the will being available through the court registry. Nicole, this next question is for you. And in this case, my ex-husband left his entire estate to some friends. He left our children out of the will. He named one of the beneficiaries as an executor. What rights do our children have in his estate?
So they have rights under Section 60 of the Wills, Estates, and Succession Act. So we used to have a legislation called the Wills Variation Act of British Columbia, and that was encompassed in the new, what we call WISA, Wills, Estates, and Succession Act, that came into force in 2014. And it says you must make, quote, adequate provision for a spouse and or child. So the children would, assuming they're the legal, i.e. biological and or adopted children, are entitled to make a claim that it's unfair. The other ways to attack a will is you can say that the will maker was incapable when he signed it, or you can say that there was undue influence. So there's ways to basically punt the will completely by saying it was invalidly entered into. Or you can also say it didn't meet the criteria of Section 38 of WISA, like it wasn't signed correctly, although that can be rectified under Section 58 of WISA. So I would say there's 4 ways to attack the will. It wasn't signed properly, he wasn't capable, there was undue influence, and that just gets rid of the will. Or if you want to say it's unfair, then that is, the court may use its inherent authority to basically amend the will to provide for the kids.
Excellent. Thank you very much, Nicole. So if they are biological children, then they've got a number of resources available to them, and we've got information on our website about that as well. So if that's a topic that someone is interested in, we'd encourage them to go to see what we have there as well. This is our last prepared question, Nicole, and it is for you. I'll just read it. It's a little bit long. My sister is the executor, named Will, and she's not involved in my mother's life anymore. The will was made decades ago, and it instructs that $50,000 goes towards funeral expenses and upkeep of the grave. But I'm worried that my sister will not honor this because she ignores my mother and does not visit our late father at the cemetery either. What can I do to assist my mother as she now has early dementia but is still capable?
Okay, so I think the question here is whether mom has testamentary capacity. Okay, and you can have a dementia diagnosis and still meet the legal rule. And the rule actually, the law is from a case called Banks versus Goodfellow, which was actually from the 1800s. And that actually is the law of British Columbia today. And it basically sets out criteria about whether somebody had the requisite capacity to enter into a will. So I think to assist the mom, it would be to put her in front of I would choose a very experienced estate planning lawyer and put mom in front of an estate planning lawyer. And that lawyer will make an independent assessment about whether they feel that your mother meets the test of capacity. And assuming she does, she can just do a new will if that's what she chooses to do.
Super. Thank you so much, Nicole. It's so practical. We have one sort of live question in relation to this topic, and then we're going to move for a couple minutes into a live Q&A. We don't have a ton of time left, so we'll do what we can with the time we have. This question is, what can a beneficiary do if he or she feels the executor isn't doing anything or taking an excessively long time to do something? I'm particularly interested in what a poor person can do in this situation, i.e. somebody who cannot afford a lawyer.
Well, that's actually a tough set of facts. It's actually notoriously difficult to remove an executor, even if you have lots of money and hire a good lawyer. It's so, I think there's a number of pro bono services through Access Pro Bono and other services where that person could get some advice. There's also I know the UBC, it's called LSLAP. There's a free legal service clinic UBC from law students. So if I was somebody that didn't have a ton of money, I would be pursuing those avenues. But just heads up, it's not easy at all to remove an executor, and taking a long time. So just be warned, it's there is recourse, but it's a bit of a process.
Absolutely. Unfortunate circumstances. I'll turn to another question that we have that we received in advance, which is: a deceased died without a will. An aunt applied to be administrator of the estate, valued at about $400,000. The only assets were investments. The deceased lived in a care home only owned belongings in her room. The administrator is paying herself the full 5% value as her fees. Does this seem appropriate?
So we don't have enough facts. But, maybe not. So I think you would negotiate with them to a lesser amount. And again, if you're not able to reach agreement, then if I'm assuming you're a beneficiary, so just don't sign the consent, and she can't take the fee without the consent. So then a judge is going to decide.
Super. Thank you. Here's another question. If you have a joint bank account, will the funds be frozen at the time of death?
No. A joint bank account will pass by right of survivorship. So the surviving joint account holder will still be able to use the funds in that joint account.
Okay, excellent. And can a burial expense be confirmed as a liability on the estate when you submit the probate application?
It's usually not included as part of the debts and liabilities, but funeral expenses are actually at the top of the list to be reimbursed from the estate before anything else. So even before the executor's remuneration, the funeral expenses get paid. They're like the top of the line of priority among creditors of the estate.
Okay. And I have one last question. We're almost at 1 o'clock, so I'll just ask this last question, and it's kind of the opposite of our earlier question about the unexpected debt. If you have an estate that does not need probating and distribute money, and a year later a check comes in payable to the estate, how do you cash the check to distribute the money?
Well, if the executor is under an ongoing obligation to deal with the estate, and so if they have an asset that comes in that they weren't aware of when they did the probate application or the estate grant application, then they will need to then do what's called a supplemental affidavit of assets and liabilities in form P14 and disclose that asset to the court and pay the proper probate fees on that asset so that they can then deal with the funds.
Fabulous. So there is a process for that. Thank you so much, Stacey. And I think it's time for us to say goodbye. Thank you again to everybody who joined us. We were so delighted to have you here today. And we appreciate you being here. We appreciate your feedback, and we look forward to seeing you at our next webinar.